Hello and welcome dear students. Today we are going to discuss a topic on consideration under law of contract. The objectives of today's lecture will be: number first, concept of consideration; second, legal requirements of consideration and exceptions to consideration. Consideration is one of the essential elements of valid contract under section 10 of Indian Contract Act. Even section 25 of Contract Act opens with a declaration that an agreement without consideration is void. In Run vs. Hughes, Baron Signor observed, "Is undoubtedly true that every man is by law bound to fulfill his engagements. It is equally true that the law of country supplies no means nor affords any remedy to comply the performance of an agreement made without sufficient consideration." Now let us discuss the various definitions of consideration. Blackstone: consideration is a recompense given by a party contracting to the other. Pollack: consideration is a price for which a promise of other is brought, and a promise thus given for a value is enforceable. Another definition of the consideration has been given by the another jurist, Patterson. Consideration means something which is of some value in the eye of the law. It may be some benefit to the plaintiff or some detriment to the defendant. Cheshire and Fifford: the expression consideration has to be understood as a price paid for any promise has been commended. Last Justice in Cure vs. Misa: in this case, it was held that consideration is some right, interest, profit or benefit accruing to one party or forbearance, detriment, loss or a responsibility given, suffered or undertaken by the other. The judgment thus refers to the position of both the promiser and the promisee in the agreement. Section 2D of the Indian Contract Act 1872 defines consideration as when at the desire of the promiser, the promisee or any other person has done or abstains from doing or does or abstains from doing or promised to do or abstains from doing something. Such act or forbearance or promise is called consideration for that promise. From the definition, we can conclude that consideration is doing or not doing something which the promiser desires to be done or not done. Consideration must be at the desire of the promiser. Consideration may move from one person to any other person. Consideration may be past, present or future, and consideration should be real though not adequate. In most cases, the promiser for doing any act or not doing an act deserves some benefit by way of consideration. Thus, consideration is identifiable benefit as quid pro quo from the promise or forbearance of the promiser. But it is also possible that there may not be identified benefits towards consideration. For example, A promises to carry B's goods free of charge and B allows A to carry the same. Here, B does not offer any consideration to A. Is this a valid contract? The answer to this question is B has suffered a detriment or disadvantage while allowing A to carry his goods. This illustration is given essentially to prove the point that consideration could not necessarily gain or advantage to the promiser, but it can even be a loss, detriment to the promisee. That is why consideration is referred to as a concept within double aspect. It can also be seen that consideration is mutual. For instance, if A promises to sell his house to B for rupees 10 lakh, here A is a promiser and B is promisee. In the same transaction where B agrees to buy the house for rupees 10 lakh, B will be the promiser and A will be the promisee. Here A must part with his house and B must part with rupees 10 lakhs. This proves the point that consideration is mutual and has two sides. Consideration is a promise or performance that party exchange with each other, and the forms of consideration is some benefit, right or profit to one party or some detriment. Now the question is whether gratuitous promise can be enforced. The term gratuitous means free of cost or without expecting any return. It can therefore be inferred that gratuitous promise will not result in any agreement in the absence of consideration. For instance, a promise to subscribe to a charitable cause cannot be enforced. Now students, let me move towards another aspect, that is legal requirements regarding consideration. The first element of the legality for the consideration is that consideration must move at the desire of the promiser. Now what it means? It means that consideration must move at the desire of the promiser, either from the promisee or some other third party. But consideration cannot move at the desire of the third party. Let me explain this. Where a collector has passed an order that anyone using the market constructed by the zamindar for the purpose of selling his goods should pay commission to the zamindar. It was held that it was not a proper order, as a desire to receive consideration has not emanated from the zamindar but from a third party, namely the collector, as this was held in Durga Prasad versus Baldev. On the other hand, a mere promise to contribute some amount for a charitable purpose may not be enforceable. But if an exchange of such a promise something is done, then the same will be enforceable. In Kedarnath versus Gauri Muhammad, persons were asked to subscribe knowing the person to which the money was applied, and they knew that on the faith of their subscription an obligation was to be incurred to pay the contractor for the work. Under these circumstances, this kind of contract arise. The subscriber, by subscribing his name, says in effect, in consideration of your agreeing to enter into a contract to erect or yourself erecting this building, I undertake to supply the money to pay for it up to the amount for which I subscribe my name. That is a perfectly valid contract and for a good consideration. It contains all the elements of the contract which can be enforceable in law by the persons to whom the liability is incurred. In Abdul Aziz versus Masoom Ali, the defendant promised to pay a sum of rupees 500 on donation for the repair and the construction of a mosque. Nothing was done to carry out the repairs and construction of the mosque. The defendant refused to pay the amount. It was held that since nothing has been done on the faith of the promise, there was no consideration in this case, and therefore the defendant was not liable to pay the subscription promised by him. Consideration can flow either from the promisee or in any other person. The consideration for a contract can move either from the promisee or in any other person. This point is made clear even by the definition of the word consideration, according to which at the desire of the promiser, the promisee or any other person doing something is consideration. Consideration can legitimately move from a third party is an accepted principle of law in India, though not in England. Executed and executory consideration. Where consideration consists of the performance, it is called executed consideration. Where it consists only a promise, it is executory. Past consideration. The next issue is whether past consideration can be treated as consideration at all. This is because consideration is given and accepted along with the promise concurrently. However, the Act recognized past consideration as a consideration when it uses the expression under section 2D has done or abstains from doing. But in the event services being rendered in the past at the request or desire of the promiser, the subsequent promise is regarded as an admission that the past consideration was not ungratuitous. The plaintiff rendered services to the defendant at his desire during his minority. He also continued to render the same service after the dependent attained majority. It was held to be a good consideration for a subsequent express promise by the defendant to pay an annuity to the plaintiff, but it was rendered that if the services has not been rendered at the desire of the defendant, it would not be hit by the section 25. subsection B of the Act as was held in Scindia versus Ibrahim. Adequacy of consideration. Consideration need not necessarily of some value as of the promise for which it is exchanged, but it must be something which can be adequate as well as inadequate consideration would not invalid an agreement, but such inadequate consideration could be taken into consideration by the court in deciding whether the consent of the promise was freely given. In Chajutamal versus Rampal Singh, the Supreme Court reiterated that consideration need not to be material and may be even absent. In this case, the father has died, leaving his house to two sons. They had agreed to partition the house, which does not admit the division in exactly equal parts, and one of the sons had agreed not to construct a door at a certain place in his portion of the house, that it was without consideration. The Supreme Court came to the conclusion that the motive of the said agreement at the time when it was made was to avoid any dispute in future, and held that it was sufficient consideration. The above view is in the tune with explanation 2 to section 25 of the Act, which provides that an agreement to which the consent of the promise is freely given is not merely because the consideration is inadequate. Where there is a valuable consideration, the court will not interfere and inquire into the adequacy of it, but leaves the matter to the parties to make their own bargain. But inadequate consideration may raise suspicion about the free will of the promiser. The promiser could be treated as a victim of some imposition, but this would not render the agreement void. Performance of what one is legally bound to perform. The performance of an act by a person what is legally bound to perform, the same cannot be considered for a contract. Hence, a promise to pay money to a witness is void, for it is without consideration. Exceptions when agreement without consideration is valid. Section 25 of the General Rule declares that an agreement without consideration is void. The section, however, mentions three exceptions: when there is no need of any consideration for the want of consideration. Performance of a legal duty is not a consideration for a promise. This principle of English law was adapted by Madras High Court in Sheshant Chatti versus Ramaswamy Chatti, although the Act contains no provisions on this point. Performance of contractual obligations. Compliance with legal obligations imposed by the contract with the promiser can be no consideration for a promise. An illustration is supplied by the fact of Ramachandra Chintaman versus Kallu Raju. The plaintiff accepts a vakalatnama from a defendant to act for his in certain suit on receiving his usual fees. Subsequently, the defendant agreed to pay him a certain sum as a special reward if the suit was decided in his favor. The suit was decided in his favor of the defendant, who, however, did not pay the amount. The plaintiff therefore brought the present suit against him. The court held the plaintiff, having accepted a vakalatnama, was already bound to render his best as a pleader. There was no fresh consideration proceeding from the plaintiff when he obtained the agreement. Validity of contract. For the validity of the contract, the provisions is as under. Section 25. An agreement made without consideration is void unless it is expressed in writing and registered under the law for the time being in force for registration of the document, and is made on account of natural love and affection between parties standing in a near relation to each other, or unless it is a promise to compensate wholly or in part a person who has already voluntarily done something for a promisee, or something which the promiser was legally compelled to do, unless it is promise made in writing and signed by the person to the charged therewith, or by his agent generally specifically authorized in that behalf, to pay wholly or in part a debt of which the creditor might have enforced but for the law of limitation of suit. In any of these cases, such an agreement is a contract. With this, we come to the end of today's lecture. Hope you have enjoyed and understood it very well. Thank you for watching.